In this show, we bring you new policy changes and stirring developments in the vivid world of the Indian bureaucracy.
Today, we take you through the implications of an apex court decision, news of bureaucrats in trouble, and some flurry caused in bureaucratic circles by 3 chief ministers. But first, let's start with a peek into the salary and perks of members of parliament. Indians, especially the media, has always criticized members of parliament voting for a salary hike for themselves. Once again, salaries and perks of members of parliament may soon be increased. Actually doubled, as recently proposed by a panel of MPs. A bill to amend the Salary Allowances Pension of MPs Act 1954 is expected to be moved in the winter session of Parliament. With the government accepting the recommendation of the 7th Pay Commission for salary hikes across the board, MPs too have proposed to double their own salaries. The bill also proposes an automatic periodical increase in MPs' salaries to perhaps escape the adverse media spotlight whenever MPs increase their own payouts. But before we go into the question of whether MPs should decide their own pay hikes, let's find out from MPs themselves how much they earn today and how much is the proposed increase. Let's hear Member of Parliament Mr. Sandeep Dixit, who is also the Congress Party spokesperson.
Currently, I think the total salary is about 50,000 plus about 50,000 for office expenditure, etc. But it comes to about a lakh or so. See, let's separate this whole thing into 2 parts. One is salary, which is purely for the purpose of your self-consumption, right? And I think for a kind of a living that you need both in Delhi as well as at home, and to, I suppose, provide a kind of a lifestyle that would allow for a publicly involved person. A publicly involved person means you have far many more issues of people coming to home, and there are expenditures involved with that. I would say, certainly a hike from about 50,000 plus is very clear.
MPs also enjoy other perks. Let's see how much India spends on its members of parliament. While an MP's basic salary is Rs 50,000 per month, he also earns a constituency allowance of Rs 45,000, which covers office expenses of Rs 15,000 on stationery and postage and Rs 30,000 towards the salary of a personal secretary. Both these payouts are now proposed to be doubled. In addition, an MP also earns a daily allowance of Rs 2,000 for each day he signs the Parliament Register while it is in session, including the holidays in between and 3 days prior and after the session. Even the meals within Parliament are heavily subsidized. Of course, an MP needs to travel, so he receives a travelling allowance for self and an assistant. He is allowed first-class air-conditioned travel on railways for unlimited journeys. By air, he is eligible for 34 single air journeys every year, with unused journeys allowed to be carried over to the next year. An MP's spouse can also travel free by air up to 8 times a year. For road journeys, an MP would receive Rs 16 per kilometre. If an MP wants to buy a car, he can avail of an advance of Rs 4 lakh as a loan repayable in 60 monthly installments. In addition, he is entitled to free accommodation, water and electricity, free medical facilities and other perks, including an allowance of Rs 60,000 per quarter towards maintenance of sofa covers, curtains and furniture. He also has a virtually free use of telephone, mobile and broadband. Even after retirement, MPs get a pension of Rs 20,000 per month, in addition to Rs 1,500 per month for every year in excess of 5 years. This is proposed to be increased to Rs 35,000 with incremental of Rs 2,000 for every additional year of service. They continue to enjoy free rail travel facility and medical facilities post-retirement. Even after the death of the MP, the spouse or dependent can receive 50% of the pension for life. The Joint Committee on Salaries and Allowances, with 15 members of Parliament, 10 from the Lok Sabha and 5 from the Rajya Sabha, and headed by BJP member Mr. Yogi Adityanath, has proposed the amendment to the Salaries Allowances Pension of MPs Act, which is pending clearance from the Union Cabinet. The Act was last amended in December 2010, when MPs gave themselves a threefold salary hike from Rs 16,000 to the present Rs 50,000. What is the justification for an increase? Can MPs randomly hike the payouts? Or is the position of an MP in the official hierarchy a consideration? Let's hear Member of Parliament Mr. Sandeep Dixit, who provides a possible explanation.
We outrank even a Secretary Government of India, okay, in terms of our protocol. Okay, if we outrank a Secretary Government of India, then obviously our salaries will have to be more than that of a Secretary Government of India, which is actually huge.
But that is not so. Perhaps because unlike the secretary to the government, an MP is elected directly by the people. Historically too, an MP received only a token amount as consideration to work for the people and be a part of the greatest democracy in the world. Consider the monthly payouts to MPs since independence. Today, the salary of MPs has increased 50-fold. What is the reason for such increases? There is a change in perspective. Salaries are higher to enable capable professionals to consider public life and work for India's development with autonomy. So the increment perhaps tries to keep up with the expenses an MP needs to bear.
The other part is what you get in terms of perks or facilities like salary for a PA or house rent allowance or whatever are the other stuff that they get. Now there my whole saying is I think much more should be given and it should not be given in cash.
True, an MP needs support staff to maintain an office. For example, as per a UNDP report published in 2012, in the USA, the American congressman can hire up to 18 permanent employees as support staff. So the real issue is primarily MPs approving their own salary increases and doubling it too. Does that amount to a conflict of interest? Let's hear former Major General Mr. Anil Verma, who heads the Association for Democratic Reforms.
Nowhere is the salary doubled whenever it is revised, whether it is after 5 years or 6 years, you take the pay commission or any other this thing. So there has to be some sort of a rationale, and since they do it themselves, so most of the people agree also. Yeah, there is an obvious conflict of interest because our stand has always been in this that, in certain other countries, the developed ones especially, you find that there is a special committee which comprises of other eminent people, who decide on the salary of these, VIPs, or which includes not only the legislators but very senior bureaucrats or people of the defense forces and this thing. So perhaps India is the only democracy where they do it themselves.
Should an independent body review the payouts to MPs, or could we develop a GDP-based rationale for salaries, a system that prevails in some foreign countries? Or perhaps consider the size of the constituency in fixing MP salaries? But even this may pose some difficulties, as Mr. Sandeep Dixit points out.
You have an independent outfit, but who do you actually make an independent outfit? You could do that. Then what you could do is maybe Parliament at any one point of time could debate the norms of that. So you have a normative system that look, this is what you base it on. What happens in Singapore or Hong Kong somewhere, where members of Parliament or those who elected, their salaries go up by the GDP growth every year. Okay, of course, problem is you have state-wise GDPs. But my whole thing was if you actually have the GDP rates, take the 51 salaries, we would be getting about 3.5, 4 lakh actually today. Because if you actually take a GDP growth, so actually it's not unfair thing. I don't think a GDP growth is an unfair number. But on the other hand, many of us actually don't believe in GDPs. GDP is not the only barometer of growth. In fact, it's a very distorted barometer of growth.
To inculcate transparency into the system, could MP salaries be correlated with performance or even attendance in Parliament? Let's hear Mr. Dixit on linking pay to performance.
See, linking with non-parliamentary performance also, even parliamentary performance is very difficult. I have been a whip of my party and then a chief whip for a while. I know, for example, that giving people time to speak, which is a party prerogative, depends on large number of things.
What about attendance? Mr. Anil Verma explains the issue with MPs' attendance in Parliament.
There are a lot of people who hardly come, and especially the Rajya Sabha MPs, especially the nominated ones, they some very renowned names who just attended once or twice, like Sachin Tendulkar and all. So there has to be some sort of a penalty on them, I think.
Penalties could be a setback for these people's representatives, especially considering that Indian MPs are among the lowest paid in the world. Consider this, a report published by the Inter-Parliamentary Union, the International Organization of Parliaments, compared MP salaries in the year 2012 across 104 countries. The results are adjusted to purchasing power parity based on the World Bank's conversion factor. Indian MPs receive a salary in the range of 25,000 PPP dollars per annum when only basic salary is considered. The salary goes up into the 75,000 PPP dollars per annum range when allowances are included. Countries like US and Israel pay their MPs more than 100,000 PPP dollars per annum. An MP from South Africa receives double the salary of an Indian MP. Even an MP from Brazil receives more than 6 times the basic salary of an Indian MP. Like India, parliamentarians in US and Germany too determine their own salaries. Is the conflict of interest our only reasonable objection? Even the Indian Prime Minister is of the view that lawmakers themselves should not decide their pay package, and such decisions should either be taken by a body similar to the Pay Commission or be linked to hikes given to certain posts and ranks from time to time. Will the MP's salary hike move to the next level? We shall keep you informed.
Has the Apex Court reinterpreted the Prevention of Corruption Act? Let's find out.
Unlike the drink James Bond enjoys, the Supreme Court's decision has left bureaucrats shaken and stirred. The Apex Court has reinterpreted the law, which has taken away the protection public officials enjoy to take bold decisions and shield them against malicious prosecution. Under Section 19, subsection 1 of the Prevention of Corruption Act, no government employee may be prosecuted without the specific sanction of the competent authority. Even the court is not permitted to take cognizance of an offence allegedly committed by an official if the charge sheet was filed by the investigating agency without the necessary sanction or permission of the competent authority. But now, the Apex Court bench of Justice A.K. Sikri and N.V. Ramana have interpreted Section 19, subsection 1 and held that it is not necessary to obtain a sanction for prosecution if the public servant has been transferred or promoted to another office or even ceased to hold that office. The Supreme Court thus upheld the order of the Karnataka High Court in the case of L. Narayan Swamy. The High Court, relying on the Apex Court decision in the case of Prakash Singh Badal, has held that the appellants, who were public officials, had abused an entirely different office than the one which they were holding on the date on which cognizance was taken, and therefore there was no necessity of sanction under Section 19. The public officials had sought to quash the prosecution against themselves on the ground that cognizance was taken without obtaining the sanction necessary under Section 19 of the PC Act. Now, would the transfer of a public official take away the protection provided under the Act? Does the Apex Court decision go against the spirit of the Act? We spoke with Mr. Mohan Parasran for his comments on the Apex Court decision.
I personally feel that this goes against the spirit and intendment of the Act. The judgment goes against the spirit and intendment of the Act because the public servant has not ceased to be a public servant. The sanctioning authority is the central government. Merely because there is interdepartmental change, the transfer should not actually take away that safeguard. See, the object of the PC Act was to actually prevent vexatious prosecution.
We shall keep you posted on the future developments. The UP government introduces bill to bypass Supreme Court judgment.
The Akhilesh Yadav government in Uttar Pradesh has introduced 2 legislations in the House that attempt to bypass the Supreme Court verdict against former state chief ministers. On August 1, 2016, the Supreme Court had directed 6 former UP chief ministers to vacate their official bungalows in Lucknow within 2 months. It had also directed the payment of rent at the market rate for the period under unauthorized occupation. 1 month later, the state government introduced the Uttar Pradesh Ministers' Salaries, Allowances and Miscellaneous Provisions Amendment Bill 2016 that seeks to allot a government residence to a former chief minister for lifetime on payment of rent as determined by the Estate Department. The statement of objects and reasons states that the amendment is being made in view of security requirements of former chief ministers. This means if the bill is passed, the 6 former chief ministers of Uttar Pradesh directed to be evicted from unauthorized occupancy of their unauthorized residence could be allotted these very houses in violation of the orders of the highest court of the land. The bill also seeks to revise the salaries and allowances of state ministers in view of price rise and escalation in the cost of living. It also promises a compensatory allowance in case the government is unable to provide a residence during their term of office.
Is the Delhi LG on a power trip?
The battle between Delhi's AAP government and the Lieutenant Governor Mr. Najib Jung has escalated following the High Court's decision giving the LG administrative power over the Services Department. The Lieutenant Governor Mr. Najib Jung seems to be on a rampage and has transferred top non-IAS officials who will be replaced by IAS bureaucrats. These non-IAS officials are Mr. Tarun Seem, the Health Secretary, and Mr. Sarvagya Srivastava, PWD Secretary. Both are IAS cadre posts. Now, the LG has transferred other senior officials too. He has also suspended previous orders of the AAP government stating that the appointments made by the AAP government were illegal. The LG has created himself as the approving authority for transfer and posting of officers of IAS, DNICS, All India Services officers and equivalent officers of Central Civil Services. Work in the health and PWD departments has grounded to a virtual halt. Perhaps the Supreme Court needs to step in.
After Mr. H.C. Gupta, the IAS lobby backs another officer.
The IAS lobby has put its might behind yet another officer who, like the former Coal Secretary Mr. H.C. Gupta, is also facing charges of irregularities and has been suspended. The bureaucrat Mr. Gopal Krishna Dwivedi from the 1983 batch belonging to the Andhra Pradesh cadre and Senior Joint Secretary in the Ministry of Home Affairs was suspended following the automatic online renewal of an NGO's license to receive foreign contributions under the Foreign Contributions Regulation Act. The Islamic Research Foundation, the NGO, belongs to Islamic preacher Mr. Zakir Naik, who is being probed by security agencies. However, at the time of automatic renewal, the NGO was not red flagged for caution and has no adverse report. Election Commission inks a deal for Rajya Sabha voting.
Color matters. The Election Commission has directed that voting in Rajya Sabha and Legislative Council polls will now only be done with a violet sketch pen. This was triggered by the recent ink controversy that resulted in 12 Congress legislators' votes being declared invalid as they had used the wrong color pen to cast the vote. As per the Conduct of Elections Rules 1961, a voter needs to mark the ballot paper with the instrument supplied for the purpose. From now onwards, the pen will be manufactured by a firm approved by the Election Commission.
The 66th batch of the Indian Revenue Service is ready to serve the nation. MOS Finance Mr. Santosh Gangwa congratulated a group of probationers at the passing out parade ceremony of the 66th batch of the Indian Revenue Service Custom Excise Narcotics after 22 months of rigorous training.
Today, 66th batch of the IRS Customs Central Excise probationers are passing out. After almost 2 years of training, they would be going out to discharge their functions in the field. As the practices have completed the professional training, we have trained them all aspects of theory, law and practicals. And training is always an evolving process. You know, the new tax regime that's coming in, the GST training, that's a new thing. We have trained, this is the Forvisser part, which is basically a finishing touch.
These officers are now trained in the field of customs, drug laws and environment protection.
ये हम सब लोगों के लिए बहुत ही ऐसा कह सकता हूँ कि हम सब लोगों के लिए बहुत ही महत्वपूर्ण संदर्भ है और वास्तव में कस्टम, एक्साइज और नारकोटिक्स के जो काम करने वाले लोग हैं उनकी जिम्मेदारी जिस हिसाब से है उससे उन्हें आने वाले समय में हम इस कार्य क्षेत्र में आगे आएंगे और इस समय जो देश की आवश्यकता है उसके हिसाब से सब लोग काम कर रहे हैं और अच्छे ढंग से काम कर रहे हैं.
And on this note, we conclude this bulletin of Raisina Up. Thank you for watching.
We look forward to your feedback and suggestions at editor@tiol.in. Goodbye.
The complex legal metrics of corporate laws, IP laws, Competition Act, foreign exchange, regulatory structure, and capital market regulations affect multifarious stakeholders. It is not just knowing the headline that matters, but the substance and a comprehensive knowledge of economic issues and their influences. We at TIOL Corp Laws bring you the laws and policies which affect the corporates threadbare for wide consumption by netizens. Now the Legal Desk section brings you the latest judicial decisions with their concise head notes from Companies Act, Competition Act, Capital Market World, banking laws, and of course the evolving intellectual property laws of India. Do not forget to check out the dashboard which will keep you updated round the clock with all the important changes made in the legislature, either in the form of act, rules, regulations, circulars or notifications. We update you as soon as the changes are notified by the government and the relevant authorities. The weekly column Corp Insight is a platform where lawyers, industry professionals, policymakers, academicians, and journalists speak by contributing insightful articles on several debatable issues in the corporate world. Our online video program named as Legal Wrangle on Corp Laws. In this program, we carefully select latest crucial decisions and bring you the views and opinions straight from the horse's mouth. Yes, from those corporate lawyers and professionals who are directly involved in such matters. Our Corp Brief segment reports latest developments in the corporate world and global news that impacts the India Inc. Our regular news coverage on developments in the corridors of power, first-hand reports on policy proposals, and interviews of those who influence the economy are all aimed at making you aware and equipped with the power of information and knowledge.